I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of the challenges to the appearance of impropriety that should disqualify you. You have the opportunity to clear the air, to come clean with the American people as well as this committee, and you are evading and avoiding these questions.
Senator, if you have a question about the position that I took in public with respect to the Mayor Adams case, I'm happy to address it, and I've addressed several today.
Well, I have asked you a question that bears on the appearance of impropriety.
This wasn't confusion. This wasn't a memory lapse. This was a judicial nominee, under oath, deliberately refusing to answer a basic question about who influenced a major prosecutorial decision. And in Washington, silence like this isn't neutral. It's revealing.
I'll begin my questioning. Mr. Bove, you responded to Senator Kennedy's questions about who was consulted about the dismissal of charges against Mr. Adams. Did you ever talk to Stephen Miller before you filed the memorandum on February 10th ordering the dismissal of the Adams charges?
Senator, I responded to Senator Kennedy's questions based on a publicly filed document that described the Attorney General as a...
Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
Because it is not appropriate for me to discuss...
It is appropriate for you to tell us whom you consulted before taking action on behalf of the United States of America. You have no basis to avoid that question, Mr. Bove.
Respectfully, Senator, I'm answering that question in a manner similar to several nominees before me, including Judge Katzen.
Did you talk to anyone in the White House, including the President, about dismissal of the Adams charges before the February 10th memorandum?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of the challenges to the appearance of impropriety that should disqualify you. You have the opportunity to clear the air, to come clean with the American people as well as this committee, and you are evading and avoiding these questions.
Senator, if you have a question about the position that I took in public with respect to the Mayor Adams case, I'm happy to address it, and I've addressed several today.
Well, I have asked you a question that bears on the appearance of impropriety. Let me go on. Mr. Bove, in court, you represented, first, that there was no quid pro quo, but you said that the decision, even if there were a quid pro quo, was unreviewable by the court. Do you stand by that?
I don't think that's what I said, Senator, because it's not consistent with the rule, which explicitly provides...
Well, you said it not only once, but you said it a number of times, and the judge observed, Judge Ho said, that your position was, quote, fundamentally incompatible with the basic promise of equal justice under law. That's what he said about your position, that the decision to dismiss these charges was unreviewable. Do you stand by that assertion?
I never made that assertion, and the judge granted the motion, Senator.
He granted the motion, but he disagreed with your premise that it was unreviewable. Let me ask you, are decisions to dismiss cases, as with that one, unreviewable?
The text of Rule 48 requires, in the instances presented by the Adams case, that dismissal only be provided for with leave of the court. That's as near a quote as I can give you, and the entire brief that I submitted acknowledged that point because we were seeking the leave.
Mr. Bove, I am concerned about the quid pro quo that the judge concluded had been done. In fact, he said everything here smacks of a bargain. Everything here smacks of a bargain. But the quid pro quo that really concerns me is the one that brings you here today. You were virtually the only attorney in the Department of Justice willing to go to court and make a claim that career prosecutors said violated their basic standard of ethics. And the quid pro quo was a nomination to the Court of Appeals. That's the appearance that the American people can take away from your sitting before us with that nomination. And I think it does grave damage to respect for the rule of law, notwithstanding your assertions about your adherence to it, for you to be here as a result of that stand by you. Let me ask you about a separate issue, the firing of prosecutors and investigators who were involved in the January 6th prosecutions. You were involved in purging prosecutors who, in good faith and an exercise of their prosecutorial judgment, they went to court, they brought charges, you purged them. Isn't that correct?
I don't agree with the use of the word purged, Senator.
Well, you fired them.
I authorized the termination of probationary employees at that U.S. Attorney's Office, yes.
Because they prosecuted the January 6th rioters.
No, because I was concerned about efforts in the prior administration to embed those prosecutors as permanent employees at the U.S. Attorney's Office.
And you also fired the FBI investigators involved in the January 6th prosecution, correct?
No, that's not accurate.
You worked with Director Patel in firing them, correct?
No, that's not accurate.
Senator Schmidt.
What unfolded in this hearing goes far beyond a tense exchange between a senator and a nominee. It exposes how fragile the boundary between justice and political power can become when transparency disappears. Senator Richard Blumenthal wasn't asking Emil Bove for legal theory. He wasn't probing classified material. He asked a foundational oversight question. Who did you speak to before ordering the dismissal of criminal charges against a sitting mayor? That question goes to the core of prosecutorial integrity. In the American system, prosecutors are given extraordinary discretion, but that discretion is supposed to be insulated from political pressure. The moment decisions are shaped by undisclosed conversations with political operatives or the White House, justice stops being blind. It becomes transactional. Bove didn't hedge. He didn't say he couldn't recall. He didn't invoke executive privilege. He refused outright. And that refusal immediately triggered alarm bells, because nominees who have nothing to hide almost always welcome the chance to clarify. Judicial ethics experts have long warned that the appearance of impropriety can be just as corrosive as actual corruption. Courts don't operate on force. They operate on trust. Once Americans believe that prosecutions can be dropped because of political relationships, public faith in equal justice collapses. That concern was magnified when the discussion turned to quid pro quo. A federal judge reviewing the Adams case had already written that everything here smacks of a bargain. That is extraordinarily rare language for a judge to use. It signals deep discomfort with the government's conduct, even while allowing the dismissal to proceed. Blumenthal then connected the dots the public is supposed to consider. Emil Bove was one of the only DOJ lawyers willing to advance an argument that career prosecutors refuse to sign on to, citing ethical concerns. Shortly afterward, he was nominated for a lifetime seat on the federal bench. That sequence matters, not because it proves corruption, but because it creates a powerful appearance that loyalty may be rewarded more than independence. And once that perception takes hold, future prosecutors get the message. Challenging political power may cost you your career, while compliance may advance it. The exchange also revealed something else equally troubling: the treatment of January 6th prosecutions. When Blumenthal raised the termination of prosecutors involved in those cases, the language became technical and evasive: probationary employees, administrative decisions. But those words mask a chilling reality. If prosecutors can be removed after pursuing politically sensitive cases, every career lawyer watching understands the warning. Justice is no longer about evidence alone. It's about consequences. This is why confirmation hearings are not political theater. They are the last moment where the public, through their elected representatives, can test whether a nominee understands that the rule of law requires humility, openness, and accountability, especially when power is involved. Silence in this context is not caution, it is a choice, and choices like this shape how justice will be administered long after the headlines fade. The public deserves judges who answer hard questions before they wield lifelong power. Do you believe refusing to explain decision-making should disqualify a nominee from the federal bench? Share your view below. Accountability begins with public scrutiny.